Companies Act 2013, Unit 2 Prospectus and Allotment of Securities. Prospectus. Section 270 defines prospectus as any document named as prospectus and includes red herring prospectus, shelf prospectus, any notice, circular, advertisement or any other document inviting offer from public for subscription and purchase of shares of the company. Oral invitation not a prospectus. Last 5 years audit reports or financial statements must be attached to prospectus. Prospectus must also contain consent given by every person named in prospectus. Registration prospectus. Before issue to public, copy must be given to ROC. No prospectus can be issued 90 days after submission to ROC. Date of prospectus is the date which is printed in prospectus. If above provisions are not satisfied, then penalty of 50,000 rupees to 3 lakh. Abridged prospectus 33. Summary of prospectus attached with application. Member may request for detailed prospectus. Shelf prospectus 31. In case of similar issues of a listed company which is valid for 12 months from the date of opening of subscription list for first offer, information memorandum has to be filed explaining the changes during the period. Deemed prospectus 25. In case of issue through issue house, the prospectus must contain additional details: net consideration receivable by company, place, date, time where the agreement can be verified. Red herring prospectus 32. Incomplete prospectus. No of shares or issue price will be missing. The missing details will be filed at least 3 days before the opening of subscription list. Misstatement in prospectus 34 or 35. Remedies available: rescind the contract or show for the damages. Civil liability: every person connected is liable for reimbursement of damages. Criminal liability: every person connected is liable for penalty, which may extend up to 3 times the amount of fraud or imprisonment from 6 months to 10 years. Defense: not given consent, withdrawn consent, believed to be genuine, immaterial. Advertisement of prospectus. Not mandatory but company can on its own. Advertisement must give details like liability of company, company's object, capital structure and amount of SC. Allotment. A. Proper authority, board or committee. B. Written application. C. Minimum subscription. Section 39. A. 90% offer made, mentioned in prospectus. No allotment if not received in 30 days of issue of prospectus. Return within 15 days, otherwise directors personally liable for interest at 15% p. D. Application monies 39(2). Not less than 25% of nominal value. Must be kept in separate bank account, not used for other purposes. A. Listing of shares 41. Mandatory for issuer of shares to public, to be mentioned in prospectus. F. Return of allotment, filed within 30 days to ROC, not required for reissue of forfeited shares. Underwriting. Section 46. Commission not exceeding 5% for shares, 2. 5% for debentures. Lower rate may be prescribed in AOA, only when offered to public. Sub-underwriting can be done by main underwriters. H. Brokerage. No limit, only for professional brokers. Offer of invitation for subscription of securities on private placement. This section lays the conditions through which invitation can be made. The law contained in the provision is as follows. A. Issue of private placement offer letter. B. Offer invitation to number of persons. C. Offer invitation made to more than the prescribed number of persons. D. No issue of fresh offer invitation. A. Offer invitation treated as public offer. F. Payment of amount. G. Time for allotment of securities. H. Default in allotment of securities. I. Separate bank account. J. Offers made to the persons whose name is recorded. K. No publicity required. L. Filing with the registrar. Acceptance of deposits by companies. Deposits from the public are an important mode of finance in the corporate sector. It is accordingly necessary to control the companies inviting deposits from the public in order to safeguard the general and wider interest of the public at large. According to the definition given under Section 231 of the Companies Act 2013, the term deposit includes any receipt of money by way of deposit or loan or in any other form by a company, but does not include such categories of amount as may be prescribed in consultation with the RBI. Whether a company can buy back its own securities. Section 68 of the Companies Act 2013 provides the power of a company to purchase its own securities subject to certain conditions. Prohibition for buyback in certain circumstances. Section 70. This section of the Companies Act 2013 prohibits the company for buyback in the certain circumstances. 1. The provision says that no company shall directly or indirectly purchase its own shares or other specified securities. A. Through any subsidiary company including its own subsidiary companies or B. Through any investment company or group of investment companies or C. If a default is made by the company in repayment of deposits or interest payment thereon, redemption of debentures or preference shares or payment of dividend to any shareholder or repayment of any term loan or interest payable thereon to any financial institutions or banking company. Membership. Section 255 says member includes A. All the subscribers to the memorandum. B. Those who have agreed in writing to become the member of the company and their names are entered in the members' register. C. Those who are named as beneficial owners in the depositories books. Modes of becoming a member. A. By subscribing to MOA. B. By purchasing shares of the company. C. By providing guarantee. D. By applying in writing for membership and their name entered in members' register. A. By becoming beneficial owner. F. Member by estoppel. G. By transfer or transmission.